Hi, I'm Anna Denton-Jones of Refreshing Law, and in this film I'm going to be explaining a little bit about settlement agreements in corporate transactions. Obviously it's going to be a generic description and we'd need to look at your own particular documentation. Settlement agreements are used by employers in lots of different circumstances, and just one example will be where a buyer is buying either the whole or part of a business and they wish to ensure that there aren't any employment law related claims that are going to emerge, perhaps from a vendor who is leaving the business as part of the transaction, or perhaps only staying on for a short period after completion. So they want to know that they're taking that business on with the certainty of knowing there's no nasties in the employment woodwork. And the settlement agreement is just a mechanism that is used to enable them to do that. Settlement agreements are a statutory concept. There's legislation governing what has to be in them, and one of the rules is that in order to make them a binding document, a solicitor has to give advice on the particular document and explain how it works to the individual, which is of course where I come in. In wider circumstances, it's often the case that the employer will be paying the employee a premium for entering into this kind of documentation, the sort of price that the employer is paying, if you like, for getting that certainty that they want, that there aren't any claims going to arise. In a corporate transaction, that's often different. It may be the case that the buyer views that they're already paying somebody a lot of money for their business, so they don't need to pay them any extra in the documentation, or maybe the documents are drafted by the corporate solicitors acting for the buyer to provide for maybe the payment of £1 as a nominal sum to make the document binding. Other times the documents are drafted as deeds, so that isn't necessary in order to make them binding. But essentially what often happens in these cases is that we're taking a document that's used in lots of wider circumstances and we're sort of boiling it down for use in the corporate transaction. So we need to look and see what clauses are in there to make sure it's fit for purpose for the particular use that we're using it for. There's often things in settlement agreements to protect the employer. They're drafted by the employer's solicitors, so they tend to be a little bit one-sided from that perspective. And there may be things in them that you feel are perhaps addressing issues that you see as unnecessary, or you have absolutely no intention, for example, of bad-mouthing the employer, but there's something in the documentation around that. That's often because one employee somewhere once upon a time did something and the lawyers sort of advise the employer around that going forward, to make sure that in any settlement agreement, doesn't matter who's signing it or what the circumstances are, we're protecting employers from that sort of problem. So I wouldn't take some of the things too personally if this is applicable to you. So what is my job when I'm looking at the settlement agreement? I'm probably looking at 5 main things. I'm looking to see if there's anything out of the ordinary that I wouldn't expect to see there. I'm checking that you're going to be paid everything that's due to you up to completion of the deal. Often the buyer doesn't agree to pay holiday pay in respect of holiday that has accrued but not yet been taken. Typically, when your employment ends, you're owed that holiday pay. Again, it might be something that as part of the wider transaction, somebody is receiving a lot of money, so we're not going to worry about a few days holiday pay, but we need to talk about that. If a payment is being made, I need to think through the tax consequences of that. Any payment that equates to the equivalent of taxed. It's called a post-employment notice payment, and that cannot be paid tax-free. Above and beyond that, money can be taken out tax-free up to 30,000. So sometimes we're looking at the tax treatment of payments. I'm of course going to want to know whether you have got any potential claims against the employer. I'd be particularly interested if you had a personal injury, for example. And I'm going to be interested in what restrictions are going to be binding on you when you've left. They may come from your contract of employment. They may come from the wider deal. Typically, you'll expect to have restrictive covenants preventing you from perhaps working in the same industry or doing certain things with customers and employees and things after you leave. So my job is to check in on those things. I'm also going to be interested in things like whether or not you need a reference, and what you can say to third parties, because there may well be gagging clauses in the document that restricts what you can say. And of course, you need to be able to say something to people about perhaps why you've left. Might be obvious because you've sold your business. Document's not binding until it's signed by everybody, and we have to keep the document confidential until we do. In terms of the main things that are likely to be in there, there might be a tax indemnity provision if a payment is being made to you tax-free, so that the employer has some recourse against you if HMRC decide for whatever reason that money should not have been paid tax-free. There might be provisions around you returning property. So if you are going to be keeping anything, then we need to think that through. You may be required to provide assistance after completion. There might be a period of handover, but there might also be the need for you to assist, for example, if there was any court cases or health and safety investigations, things like that. We might want to talk about how long those sorts of things would go on for and whether you'd be paid anything in return for providing that support. And as I mentioned, the gagging clauses that we spoke about earlier. There will also be some clauses that are around really putting a marker in the sand and saying that that's it, we can't bring any claims. So things like claims for breach of contracts, so we want to make sure you've been paid everything, claims for unfair dismissal, claims for discrimination. There'll be a whole list of things that are included. And I'll also be looking to check that certain things have been carved out of that. So, for example, if you became aware in the future of a personal injury claim, I don't know, maybe asbestos in the roof or something that you don't know about now, that you could still bring a complaint about that against the employer's insurance if you needed to in the future. Obviously, your pension pot needs to be your own. There may be data protection claims that we need to protect going forward. For example, if there was cyber hacking and data got leaked. There's likely to also be some promises in the document that you're making, so promising that you haven't done anything hideous, that you've hidden, that you haven't already issued claims. Those sorts of things are likely to be in there. And there may well be a document or clause around saying this is it, this is the entire agreement between the parties. And I often find that we need to change the wording of that clause because, of course, in a corporate transaction, it isn't the only document. There may be a fresh contract of employment if you're staying on, or a consultancy arrangement. We may need to refer to the business purchase agreement or share sale agreement that's we're entering into as part of the documentations. We may need to just tie the documents together. Typically, in terms of fees, the employer tends to pay a contribution towards the employee's legal fees. That tends to be something that gets left out in corporate transactions because you'll probably have them to pay a lot of legal fees for the whole transaction anyway. But it may be that some of that is allocated in the particular documentation, so we need to look at that. If there was going to be any long gap between completion and, for example, signing of the documentation and the deal actually taking place, there may be the requirement to sign the documentation twice as well, so we'd need to look at that. I look forward to talking to you about your own particular circumstances. If you do have any questions that you'd like to ask, my email address is adenton@refreshinglawlimited.co.uk. Thank you very much.